Thanks for listening to A Long Time in Finance with Jonathan Ford and Neil Collins, in partnership with Briefcase.News, the service that brings intelligent curation and analysis to your media monitoring. So welcome to A Long Time in Finance, and today we're doing a special episode with another podcast, Law and Disorder, and we'll be talking about the convictions for libel manipulation. So I think we should start just by introducing ourselves. I'm Jonathan Ford.
And I'm Neil Collins.
I'm Helena Kennedy.
And I'm Nicholas Mostyn. Now, libel was invented back in 1969, but we lawyers know not much about it, do we, Helena?
I know very little about it. I do remember there was a bit of a scandal at one stage, but I couldn't tell you really what the basis of it was.
So shall we hand over to the experts?
To the experts. I really want these financial experts to tell us all about it.
Okay, so libel, what does it mean? The letters stand for the London Interbank Offered Rate. And it's essentially a mechanism for determining an interest rate at any given juncture. And it's based theoretically on the amount or the rate at which a group of large international banks can borrow in various currencies. It was invented in 1969 by a Greek banker called Minos Zombonakis.
Now, we should interpose here to say that we have a personal connection with Mr. Zombonakis, don't we?
We have his godson in the room.
We have his godson as our producer, Nick Hilton.
Hopefully he gave you some nice presents over the years.
It sounds like a fix. Is it not a fix?
It's a sort of fix.
It's a fix. It's basically the bankers all getting together and saying, we're going to fix the interest rate so there's no competition, so the ordinary person can't shop around, and we're just going to fix the interest rate and it will serve our interest best. Was it not that?
No,
not really.
That's not right. It is the rate between the banks. It's not the rate that they were offering to people in the street. So this was to balance the books from day to day, essentially.
So a good fix or a bad fix?
Well, it was fixed between the banks with no external implications.
Well, maybe it's worth talking about what it was invented for. It's not really invented for the banks to all collude on interest rates so that there's no competition.
I'm always suspicious about these
things. You're very, very
things.
suspicious about that. But in this case, it's unfounded. Basically, what Mr. Zombonakis was trying to do was he was working for a bank called Manufacturers Hanover, an American bank, and he wanted to lend some money to the Shah of Iran.
Well, it tells you immediately my suspicions.
And in 1969, one can only hope it was a 10-year loan or no more than 10 years. But he wanted a mechanism for resetting the interest rate on what was called a floating rate loan. And he thought the best way of doing it, the Shah of Iran, he thought, perfectly reasonably in 1969, was a good credit. And he thought, well, how do we decide what is the best way to set the interest rate over time so that the bank gets paid back and gets paid a reasonable rate of interest? He wanted a reference rate. And this periodic fixing allowed him to effectively set a rate for the loan to be priced at over its life.
So it floated by reference to the interest rates being offered by a group of banks.
Yeah, and the obvious assumption was that good credit in those days would have been, you would have looked at large international banks like Citibank, which were all AAA credits.
Was the Shah's good credit relating to
the
oil?
He had a lot of oil. He had a lot of oil. So he wasn't a bad bet.
Have I understood this correctly, that the way it was developed was you took 16 banks, and it would be 11 o'clock in the morning, and they would say, what interest rate would you offer to borrow money at or to lend money at? And then you would
It's to borrow.
To borrow at, and then you take the middle eight, the average of the middle eight.
That's essentially how it ended up. Yeah.
Okay. And then thousands of contracts are made on the basis of LIBOR plus 2% or something like that, aren't they?
Yeah, it was clearly something that was needed by the money markets, and it was seized upon gratefully and has been used as the basis for variable rate contracts ever since, until it was scrapped after the banking crisis.
So just tell us then about how people began to suspect that it wasn't being operated entirely honestly.
I think you have to go back to the moment in the summer of 2007 when the financial crisis begins.
Okay.
And it begins when a group of hedge funds, but they're not really hedge funds, they're effectively linked to banks, discover that a whole bunch of derivative assets that they own, or assets they own, are untradeable and have become completely illiquid. Essentially, they are all suddenly aware that they have a huge hole in their balance sheet.
Okay. So where does manipulating the Libor rate fit into that?
So basically, Libor serves two functions, and I think it's very important to note that there's another one alongside Mr. Zombonakis' idea of setting loan rates and applying those reference rates to other financial contracts. There's also, it's regarded as a sign of the health of financial institutions, because, of course, it is the rate at which banks were able to borrow from each other.
Yes.
And in the summer of 2007, essentially all borrowing between banks ceased because every bank in the world or in the West concluded that they didn't understand each other's figures anymore. They weren't sure whether any of them were insolvent, and therefore the last thing they wanted to do was contract loans or lend money to institutions which might not give it back to them.
Yes.
So all lending essentially between banks started to freeze up.
Okay.
And the natural consequence of that would, of course, be that the amount that they had to offer to borrow money would go up.
Yes.
Because they would raise the interest rate, essentially to reflect the fact that money had become scarce.
Yes, the interest rate goes up when it's more difficult to borrow.
Correct.
Yes.
I suppose one of the reasons why the bloodhounds of the financial media started to wonder about this was they saw that the Libor rate was not really moving up to reflect this tightness in the money markets.
Okay. So this indicator of suspicion was not that the Libor rate moved, but that it didn't.
Well, it didn't go up very much.
Yes. So why would that have been in anybody's interest, dishonest interest, to have kept it not reflective of the illiquidity in the market?
The problem was, in the middle of the crisis, is that the London Interbank offered rate, and the key word here is offered, that's the rate at which the banks said that they would have to pay for money that they were borrowing either overnight from other banks or for a short term from other banks. Because the other banks actually didn't really believe their balance sheet, the whole system started to freeze up.
Okay.
Basically, the participants started not participating, or at least only participating nominally, rather than in a routine, very substantial way, which is what they'd done before.
Okay.
So the system was essentially frozen. When the system is frozen, then the money in the money markets can't circulate sensibly. And you get all sorts of distortions and you get all sorts of rumours. And eventually you probably get a run on the worst banks in the system.
So the atrophy in the market, you would expect the Libor rate to go up to reflect the atrophy in the market.
Yep.
And then the suspicion is that people were behaving dishonestly by manipulating it. I just want to try and understand is what is their gain? What are the advantage going to be of the dishonest manipulator?
The dishonest manipulation at this point, i.e. in the early stage of the crisis, is not necessarily talking about people like Mr. Hayes or Mr. Palumbo,
who are coming
to later. Yeah. The contention is, and there is quite a lot of evidence that this was indeed going on, is that central bankers and finance ministers, becoming concerned that their banking system was going to fall over because of all this freeze in the money markets, encouraged banks not to post rates to the Libor fix, if you like, which was suggestive that they were in crisis. So they were encouraged to do what was referred to euphemistically at the time as lowball their estimates. Essentially, what evidence exists is of conversations between people in banks like, say, Barclays or wherever, of people saying we must reduce our submission as much as we can because the Bank of England would like us to do that.
Well, you've just taken the words out of my mouth. Are you saying that we're going to look in a minute at the guilt or otherwise of Mr. Hayes and Mr. Palumbo, that the Bank of England were encouraging people on the Libor committee or whatever the panel to do exactly what they did?
This is what is suggested, yes. And not just the Bank of England, also particularly within the Eurozone, the Banque de France was seen as basically pushing its banks to make low submissions to keep down the apparent cost of borrowing.
So you're saying it was really being used for a purpose that it was not originally set up for, but it was being used in a period of crisis. Are you saying to save the banking system and therefore in the interests of the populace? I'm speaking here on behalf of the common man and woman, and very much the common woman. The common woman
common
is
Scottish woman.
The common woman is my line. How did it benefit me? How did it benefit the ordinary person in British society.
The reason why it was done was to try and keep some liquidity into the system, because banks have to balance their books every day in terms of assets and liabilities. That's what banking is about. The reason why that they were encouraged to do this...
To lowball,
because the authorities, with good reason, were concerned lest one particular bank, any particular bank, suddenly found that it couldn't borrow at the rate that it was advertising.
I think it's worth just saying that we need to draw a distinction here between what's happening in the real world and what's happening in the world of Libor. Libor is a signalling mechanism. In the real world, not a lot is going on in the summer of 2007 into 2008. And if you're the Bank of England, what you realise is that if no one else is prepared to lend to Barclays or NatWest, the only source of money they have is you as the central bank. And the bigger that crisis gets, the more likely it is that you're going to face a whole, as Neil says, the possibility of a wholesale run on that institution, which you, as the central bank, are desperate to avoid. And you, as Alistair Darling, are desperate to avoid, because that then puts the government into the front line of trying to figure out what on earth to do. So essentially, what is going on is that the central banks are trying to use this signalling mechanism as much as possible to avoid the crisis mushrooming in the way that
I understand that entirely.
Spinning out of control.
I understand that entirely. But what happened in 2007 was that the Fed warned the Bank of England that it had become aware of Libor manipulation.
Correct.
So the Bank of England, it can't come to a very much surprise to the Bank of England, because they were probably up to their neck in it anyway, weren't they?
Absolutely, yes. I mean, but the point is, it was designed as a mechanism essentially to clear the market. It was not designed as a mechanism to defraud people.
But isn't that the moment when you have a nice conversation with the Fed explaining that this is about sustaining the system, and therefore criticism from the Fed is not going to be very helpful?
Well, I'm not sure whether the Fed criticised them rather than pointing out that that was what was happening.
I see.
We've got the central banks encouraging the Libor panel to make some contributions which were beneficial for the nation's interests.
Sounds sensible to me.
Okay, but things came to a climax in 2012, didn't they?
So the 2007-2008 fuss about what's going on with Libor becomes a subject of great interest to people in the financial media and, over time, to the regulators, because the question arises, is something fundamentally wrong with this system, and is it at all reliable? Regulators, obviously, are very interested in the question of whether markets are being manipulated or deceived by people's conduct. So they go away and they spend several years investigating what's been happening with Libor. And they come to the conclusion that on both sides of the Atlantic, that a myth has happened. But it's particularly the Americans who lead the way on this. They basically investigate a number of large international banks, the banks who are essentially making submissions to the Libor panel. And one by one, they force them into these deferred prosecution agreements where they...
And huge fines.
So $8 billion are paid in total by the banks.
I'm just sort of slightly at sea here. Yeah. These people have been threatened with prosecution, entering into deferred prosecution agreements and paying fines for doing something that they've been encouraged to do by central banks.
I think that's a pretty fair summary, actually. But, that is how the banking system works.
No, I don't think that's far too cynical at this stage. I think you've got to recognise that there is an argument that there are two sorts of manipulation going on. There's the one we've just described involving the central banks, which some people would say this is good manipulation.
It sounds like it to me.
But concurrent with that is this idea that there is also a darker side to this activity, and financial institutions are pretty adept at fiddling around with this rate and have been doing so for years. So about 2010, there was an article in the FT by an American banker, and he said, well, look, we've been doing this for years and years and years. It goes right back to the early 90s. Don't imagine that it's just a few central banks who are doing this. And so I suppose if one thinks about these deferred prosecution agreements, it's reasonable to assume that the investigation as it goes into the behaviour of the banks widens from, if you like, just looking at what the Bank of England or the Banque de France might have said in 2007, to questions of wider collusion among banks and between traders, which have led to submissions taking place which weren't completely straightforward.
Isn't it the case, though, that during this period, there was huge public cynicism about banking?
Yes.
We were all feeling that banking and the kind of, if you like, the ways in which bankers were in some way manipulating systems to make a ton of money for themselves at the expense of the ordinary punter, that cynicism probably led regulators and so on to feel that they had to be on their toes and looking for what they thought were manipulations which were outside of what might be considered in the public interest. There were lots of manipulations which were certainly not in the public interest, but were in the bankers' interest. Didn't that then lead to prosecutions which possibly ended up being somewhat unfair? They were looking for people to carry the can, and they certainly didn't want the central banks who were as guilty of manipulation, but the issue of were they for good purposes or for negative purposes, or did some people jump on the bandwagon to make excessive profits? We set up a kind of atmosphere in which miscarriages of justice can take place.
Did anybody at Barclays actually face the music?
Not at the senior level.
No.
Well, arguably, when the prosecution agreement comes out, the settlement with the SEC comes out, came out in 2012, and they paid their fine and they got ticked off. The chief executive of Barclays, a man called Bob Diamond.
Bob Diamond.
Everyone hated Bob Diamond.
Everybody hated him at the time.
Particularly the governor of the Bank of England at the time. And so he was forced to resign. But he was about the only one.
But he wasn't prosecuted.
No.
But there were some prosecutions, weren't there? Quite small fry. It was like that film Break 'em Around. You know, you have to have some sacrifice.
Favourite film.
You find some.
Maybe you have to have some sacrifice for the greater good, but they were all small fry, weren't they?
You take one for the team and you send out.
It was only the US and the UK that prosecuted. I don't think there were any prosecutions at all in France or Germany or anywhere, were there? Yeah. The UK prosecuted, you say, 37, of whom 19 were convicted and 9 went to prison, including Mr. Hayes, who was given a sentence of 14 years.
All I feel is, listening to all of this, is that where an atmosphere is created in a nation or in a climate, and it was international here, that the bankers were up to no damn good and brought us onto the verge of serious economic crisis globally, and that the system was really on the edge of the abyss and had to be saved, that at the same time there had to be seen to be some kind of action to deal with this. And you end up then becoming overactive. And I mean, I saw it with terrorism, where you end up, rounding up anybody who had an Irish accent, or you could easily end up anybody who happens to be a Muslim. There are risks associated at the edges of all of this. And sometimes some people are thrown to the lions, basically to protect those who may be more culpable. The risks of miscarriages of justice become greater, or excessive sentencing and judges feeling that they have to make an example of somebody.
No, I think there's a lot of truth in that. I mean, I was working as a journalist at the time and writing leaders for the FT. We were very aware of the extent to which people said after the financial crisis, where a lot of trust had been blown up. What's going to be done about all these white-collar people with their $1 million salaries? How many of them are going to go to jail?
Yes, but
and people used to say, why has no one gone to jail?
That's right.
So it was in that climate that this, which appeared much more clear-cut, there was a lot of very confusing stuff around the crisis about, whether the reckless behaviour which people detected was in any way criminal. There was a lot of disappointment that people taking mad bets with the financial system turned out to be something unlike dangerous driving you didn't have to go to prison for. So this presented an opportunity for some sort of legal retribution to take place.
It did indeed.
That's right.
Voltaire said, en Angleterre, on tuait un amiral de temps en temps pour encourager les autres. But this was not killing an admiral.
I was going to say this Admiral Byng, isn't it?
This was Byng. That was Byng shot on his foredeck. But this was not an admiral, was it? They didn't kill any admirals. They just killed the cabin boys.
Yeah, that's the one. Yeah, I think that's probably a reasonable summary of what happened when they did get down to prosecuting.
Yes, but the banks were made to fork up £8 billion in fines for doing something that it seems to me that they'd been encouraged to do so some years earlier.
The settlements in question involved several... I don't think if you read the deferred prosecution agreements, it says It doesn't say you're guilty of following the instructions of the Fed and the Bank of England. Those things are excluded.
And listen, can I just, for any member of the public who's not involved in either the law or banking, deferred prosecutions are a very privileged thing that exists for the financial sector, which is that a sort of deal is done where they say to, if it's a bank, we will not prosecute you if you put your house in order, and there are certain stipulations attached to the deferred prosecution order. I've always thought that we should be using it much more widely in other areas where you say to some first offender, we will not prosecute you if you stay out of trouble over the next however many years, and so on. I mean, I just think that it's a rather useful thing, but it's not been used. It's only used.
It's only be used against a company.
It's only at the moment used against some sort of corporate entity or a financial entity, and it stops them being prosecuted, but they do still have the obligations of often paying a whole lot of money back into the taxation system or into the public coffers.
Let us move on to the actual subject matter of this joint podcast, which are the Libor appeals recently dismissed by the Court of Appeal Criminal Division. Now, Mr. Hayes had faced 8 counts of conspiracy to defraud, and he was found guilty, and he was sentenced to 14 years, plus the confiscation order of nearly £1 million. The Court of Appeal actually thought that 14 years was a bit toppy and reduced it to 11.
Still sounds
They're still absolutely enormous. Now, I should just say very quickly that Mr. Hayes had earlier entered into a formal agreement with the SFO to plead guilty to offences of manipulating the Libor in order to avoid being extradited to the USA. And in the course of the interviews that he gave in that process, he admitted the manipulation and the dishonesty. So it was quite a difficult case for him to defend when he subsequently changed his mind and pulled out of the agreement to plead guilty, by which stage he wasn't going to be extradited to the USA. I mean, it was the fear of being extradited to the USA and life in a supermax prison that was absolutely forced him into do that. But one should understand that he had admitted dishonesty by the time his case came to trial here. But in my opinion, that doesn't really answer the question that has to be answered, which is a simple enough question. The instructions to Libor contributor banks in the period with which when these offences were alleged to have taken place said simply this: an individual Libor contributor bank will contribute the rate at which it could borrow funds, were it to do so by asking for and then accepting interbank offers in reasonable market size just prior to 11 o'clock. That's what the instruction was. It also said contributor banks shall input their rate without reference to rates contributed by other contributor banks. At the time, back in 2012, what did you think those words meant?
I would say it's completely straightforward, that you find a rate which you are confident that your bank can borrow, and that is what you put forward for Libor for the panel. There doesn't seem to be any qualification to it at all.
Would you have read into those words a prohibition on considering the effect of the number you put forward on the profitability of your own bank?
Absolutely not. Because if that was the intention of it, it would have said so in the original definition.
What about you, Jonathan?
I think I broadly agree, actually. There are lots of things in this which are not said. It doesn't necessarily say that you might, for example, inflate the number, reflecting the fact that you could borrow at 2.5%, but you could also borrow at 3.5%.
Yes, well, the Court of Appeal said that's a ridiculous argument. Said,
well, I agree.
Sorry, it is a ridiculous argument, because if you can borrow at you're borrowing, you're not lending, you're borrowing at 2.5%. Why would you consider trying to borrow at 3.5%? It's absurd.
Right. But what it clearly seems to me to exclude is you saying I could borrow at 2.5% when you can only borrow at 3.5%, or you could only borrow at 10%.
Exactly. See, what the Court of Appeal said in earlier decisions, and the question was, should they be allowed to depart from these earlier decisions, that those words had to be interpreted to say, as you've said, Neil, that the bank contribution has to be the lowest single rate at which it could borrow funds. And it added this: in making its contribution, a contributor is absolutely prohibited from considering the effect on the profitability of its interest rate swaps or other derivatives or other transactions held by the bank's traders, right? That's what the Court of Appeal has said in earlier decisions. They said if even to a small extent you've allowed that to influence the number you put forward, then you're guilty of conspiracy to defraud. when this came to the Court of Appeal again on a reference from the Criminal Cases Review Commission, the Court of Appeal had to consider, would that be maintained in the light of the fact that the Americans had considered this in the case of Connolly. Now, have you heard of the case of Connolly?
Only in your note.
Only in my note. Well, in the case, the same issue came before the American court in the case of Connolly, and it came in front of their Court of Appeal, who said if they had intended to exclude taking into account your own self-interest when putting forward a number, it would have said so. That's what they said. And it doesn't. And so the fact that Mr. Connolly in that case allowed the interest of his bank to influence the number he put forward was not prohibited, and he committed no offence. And the American judge said, whilst the behaviour was not illegal, it might have, as she put it, violated any reasonable notion of fairness.
Yes. Is it worth thinking about what Mr. Zombonakis had in mind all those years ago when he devised this system? And I think what he had in mind was fairly simple. He basically wanted a mechanism for trying in aggregate to figure out what rate a group of banks could borrow at.
Yes.
And I suppose the assumption he made was that these banks, the averaging process might deal with any oddities that any individual bank would throw up.
Yes.
But basically, all he was concerned with was the question of a bank, a borrower, setting out or stating the rate at which it could borrow its funds at any one given time. It seems to me that the question of whether there were derivatives or some sort of ancillary sort of thing which was preying on the mind of the bank at that time. And
no, that's a fair point. That's a very fair point.
It fiddled around with the numbers at the margins.
I understand your point now, which is try to go back to the original purpose of the Libor. Right? Yes. The fact that these ancillary purposes have developed should not deflect you from the original purpose, which was to set a reasonable average rate, a reasonable average rate at which people could say, that's what the going rate is for borrowing money, right? Yes. And so I know perfectly well, because I was a barrister for a long time, I used to do divorce agreements, and there would be agreements made for money to be paid by party A to party B, and you'd always say Libor plus X%. So it became a benchmark on which so many contracts were developed. But the fact is, there is nothing in Libor, and I think this is an important point to be made. This Libor is not the product of a statute. There's no Libor Act. There's no Libor regulations or anything like that. It's entirely informal and voluntary arrangement.
Yeah, it has evolved over time, in rather the same way as the takeover panel has in the city, an informal agreement which in the end, as I said, was invited to bear more responsibility than it ever could. But neither of those things, neither the panel nor Libor, has had statutory backing. So, as you say, there was no law.
I would have thought that Mr. Zombonakis would have been surprised if he was told that people were being sent to prison for 14 years later for violating the thing that he'd set up.
You'd be alarmed.
But the fact is, the Americans, in a classic construction of the words, I mean, they say, if they had intended to include a prohibition on taking into account your own self-interest or your bank's self-interest when you put forward the number, it would have said so, and it didn't. And so in those circumstances, what they did was not illegal, even though it might have violated all notions of fairness, okay? Now, our Court of Appeal was then asked to reconsider the convictions of Mr. Hayes and Mr. Palumbo in the light of what the Americans have said, and they finessed it away by saying, no, what you've misunderstood, the American decision is not about defining what those words mean. It's simply a question of, was there sufficient evidence to prove the charges in question in that particular case? It's simply a factual exercise about sufficiency of exercise, which I have to say is, in my opinion, I do not agree with that at all. And I think that the English and Welsh Court of Appeal, Criminal Appeal, has found a way of avoiding the inconvenient decision of the American case, because if they followed the American case, then they would have to disavow a number of earlier decisions on the interpretation of those words, which include one interpretation by Lord Justice Davis, who said that because the words do not exclude bad faith, then you could act in bad faith, which is an absurd argument, an absolutely absurd argument.
Yes, I agree. It's almost analogous to saying that if you go to the centre of a field where the rainbows end. And if you don't think about it, you will find a pot of gold. But the moment you do, of course, you've compromised yourself and it's not there.
Anyhow, these are interesting views. Whether the case will go to the Supreme Court, we're running out of time, so whether the case goes to the Supreme Court does depend on a technical question, because the Court of Appeal has to certify that it's a point of law of public importance. I don't believe that process has yet taken place. If the Court of Appeal do certify, I would like to think that the Supreme Court will consider this without the baggage of all these earlier decisions.
May I ask a question? Because what has not become clear to me in reading either your marvellous brief, Nick, and listening to our friends at the table, did either of these men serve any part of they've served their sentences now? Both of them have served their sentences.
They're all out on licence now.
Yeah. The awful thing about this is that, I just think that the sentencing was ludicrous when you put it in comparison with sort of acts of violence and all kinds of things. But I think that serious financial crime matters because it can have impacts on the general public and the public interest. But I do feel that there's something deeply uncomfortable about the fact that it's people at a lower level who carry the can. And I do think also it just seems disproportionate because a person's life is over once they're convicted. If you're in the world of finance and you're found guilty of something dishonest, then that's it. Maybe they made so much money that they can afford to retire into comfort anyway. But all I can say is that I just think that sentencing around these things also has to be revisited. And I'm surprised that the Court of Appeal didn't do that.
Yes, I don't actually understand how even the reduced sentence of 11 years is a justifiable penalty. When you look at what 11 years is given for in relation to crimes of violence, it's just not comparable unless it's for the deterrent effect.
Can I just ask, just so I understand, your view on this is that essentially...
I'm with the Americans.
You agree with the Americans that no crime was committed?
No crime was committed. I agree with the Americans. That's my view. And I don't agree with the Court of Criminal Appeal's argument for dismissing the American judgment as it being only a decision on the facts as to the sufficiency of evidence. I believe it was a principled decision which defined the meaning of paragraph A at the time. And they said that paragraph A does not exclude bringing into account your own self-interest or your bank's self-interest.
I'm not as ready to take that position as you, Nick, because I just think that sometimes making comparisons with what happens in other jurisdictions is unhelpful because culturally systems can be so different. I don't know enough about the American banking system either.
But there's also this further point. Mr. Palumbo had a third ground of appeal, which was that the basis on which he was convicted was insufficiently certain, legally certain, on which to found a criminal charge. And it was too ambiguous, the words of paragraph A, to give rise to any criminal liability, which is Article 7 of the European Convention, which you cannot be convicted of a crime unless the crime is certain, principle of certainty. And I would think that even if me and the Americans are wrong in our interpretation, there's a strong argument on ambiguity which should have stopped any prosecution.
Yeah.
Can I just go back very quickly to the idea of good and bad Libor manipulation, which we discussed earlier? This idea that there is sort of good, principled things that are done in the public interest, i.e. the central banks intervene to nudge down these rates or change them in ways that are helpful to them. There is this sort of idea that basically there is a big distinction. One is self-interested, bad, the other is principled and good. All I would say is it's not clear to me that this distinction is quite as clean as is being suggested, in that if you look broadly at what was the effect or the intended effect of the central banks changing Libor to make banks look financially stronger than they were, it was to encourage people who were investors in, for example, bank shares, to buy those shares at a value which was overinflated.
Yes, it was.
To my mind, that's not a completely kind of victimless and entirely public-spirited thing. It is in itself a deception on the public.
But your point just reinforces these were scapegoats.
Yeah, I think that the court system, in a way, was doing what is suspected of doing, which is of having interest beyond that which is apparent. And so who knows? I just think that this was about the temperature of the times, and it still lives on because people are still living the consequences of the economic crisis. We were all told at the time that it was all, Labour and government had failed, whatever. But in fact, it was a global thing with incredible consequences. And there was a general feeling that the bankers had got us into it and that they had to pay.
Well, I think that has been a very interesting joint podcast. we must reunite on subsequent occasions. But it's been absolutely fascinating. I've learned a great deal about Libor, which I didn't know before. And I hope that perhaps you've learned a bit about the law of fraud, which you didn't know before.
And if you enjoyed this episode and you're interested in learning more about the law, tune in to Law and Disorder.
Yes, and you can find us on all the regular platforms where you get your podcasts from. So it's goodbye from me, Nicholas Mostyn.
Goodbye from me, Helena Kennedy.
Goodbye from me, Jonathan Ford.
And from me, Neil Collins. That was A Long Time in Finance with Jonathan Ford and Neil Collins. Production and editing by Nick Hilton, and our sponsorship partner is Briefcase.News. If you enjoyed the show, please rate and review it on your podcast app, as that will help new listeners find us.